If you're in contract and you're not married, like what's a certain way to hold title? Because I get a lot of questions and I'm a lender, so I can't answer title questions. But what are the different ways that clients can hold title? Like if they're unmarried or if it's like family members buying or if they're married. Can you explain the difference? And
Sure.
that question they're going to get, and maybe first time buyers don't even understand some of that.
Okay, so first things first is who's the contract name, who's purchasing, who's going to be on the loan. If both parties are on the loan and they're not married, there's really two options that they can have. One, it's tenancy in common, which means each party owns 50% and they have to pass their 50% share in a will. No one automatically inherits it. If something happens to one party, that person's estate controls the interest of 50%. The other option is joint tenancy, and it's essentially with a right of survivorship. So if you are close family, sometimes fiance, hopefully getting married soon, you want the other person that's on title, since they're vested, they're taking on the liability of the mortgage, to inherit the property from you. So if you put them as joint tenants, whatever happens to one party, the other party automatically gets 100%. It doesn't matter if there's a will. It doesn't matter if you didn't intend it that way. As long as you're in joint tenancy, it's automatic. So as two people that are not married and going on title together, you have two options, unless a lender allows you to put it in a trust.
Yeah, and we will allow for living trust. So if you do have a living trust, which prevents probate, which is very good for a lot of clients, you can close in trust. We just require a copy of the trust and the certification of trust to make sure that it is your trust. So we will allow that. What if it's like a married couple? How would they, hold title? Would they do joint tenancy, or is there something different?
Well, as a married couple, you actually have a third option also. So you have the first two options that we went over, joint tenancy, tenants in common. But you also, if you're purchasing it as your primary residence, a house that you're going to be moving into, and it's the only one you're going to have in Illinois, you can have it as a tenancy by the entirety. What means that is, this is going to be my primary residence. I want my spouse, who is going to be on title, to automatically inherit my property. But I also want it to be protected from creditors that may be only owed by one party, not the other. So a mortgage, if you sign both on the mortgage, you're both liable. That goes against title. But let's say the wife went on a shopping spree, built up a credit card debt, and now the credit card is pursuing them in court. Well, that credit card, unless it's a joint credit card, cannot lien against the property because they are owned by tenancy by the entirety. So then it's extra bonus. Not all states have it. Illinois does. And you can only have one property as tenancy by the entirety, and it has to be a primary residence. It cannot be an investment property.
Okay, great. That's great, because it depends state by state. So you'll have to check your local, guidelines on that.
Remember, I'm here for all your mortgage needs. While I do renovation lending, I also do move-in ready. So if you're unsure whether you want to get a fixer-upper or a move-in ready, I can handle both. So please subscribe to my YouTube channel for more news, market updates, and opportunities to save money.